morning. Thanks for coming out. 7 years ago, the Democrats enacted the Dodd-Frank Act, which was a mistaken and damaging piece of legislation that regrettably has made us less free, less stable, and less prosperous. Tomorrow also represents the 6th anniversary of the Orwellian name Consumer Financial Protection Bureau, which is potentially the most powerful, unaccountable agency in the history of our republic. This agency is so radical and free from accountability that, as you may know, a D.C. Circuit Court panel recently declared its governing structure unconstitutional. The CFPB's director, Richard Cordray, served illegally for 18 months under an unconstitutional recess appointment and has been caught contravening the law on a number of occasions, whether trying to regulate car dealers without authority, serve subpoenas on organizations over which the CFPB has no jurisdiction, or even by allegedly retaliating and discriminating against CFPB's own employees. Under Mr. Cordray's leadership, the CFPB has shown an utter disregard for protecting markets and has made credit more expensive and less available for many hardworking Americans, particularly low and moderate income Americans. What is also clear is that under Mr. Cordray's leadership, the CFPB has denied market participants due process and abused its powers, which brings us to why we are here today. Though it is widely reported that Director Cordray will soon seek political office, he has stayed around long enough to rush out a midnight rule on July 10th that will enrich the politically powerful class action attorneys at the expense of consumers. This rule effectively takes away the right of a consumer to freely enter into a contract for financial services that provides for fair and efficient alternative dispute resolution. Let's be clear. One bureaucrat in Washington has decided that he knows better than the American people, and he's acted unilaterally to dictate the terms of contracts in a way that will affect the cost and availability of financial products for millions of Americans. No unelected individual in a free representative democracy should have so much power. On its face, this legally dubious rule is bad for consumers. According to CFPB's own study, only a small percentage of class actions ever actually provide financial benefit to consumers. The average payout to consumers from class actions is roughly $32 on average. Compare that with the thousands of dollars that CFPB reported estimated consumers received in the average arbitration. The Bureau's own study also concludes that arbitration is up to 12 times faster than litigation. So if you have a dispute with a company over a product or service and its value is small, what do the American people want? A fair chance at resolution in a matter of weeks or months, or a coupon in the mail several years later. It's clear that if the CFPB's rule takes effect, consumers will lose. But who will win? The CFPB study admitted that the plaintiff's lawyers made about $1 million per settled case, or about 31,000 times more than the consumers in the class receive. CFPB also estimates in its final rule that costs for companies will increase by over $1 billion per year, of which almost $400 million will go to the trial attorneys, which only means increased fees and cost for consumers. As a matter of principle, policy, and process, this bad rule must be reversed. That's why I commend the gentleman from Pennsylvania, Mr. Rothfuss, for his leadership in introducing a resolution to repeal the rule under the Congressional Review Act, and I'll now turn the podium over to him.
Thank you, Mr. Chairman, and good morning, everybody. The CFPB's anti-arbitration rule offers a teaching moment for the country about how when liberal elites in Washington, D.C. pander to special interests, they end up hurting the very people that they are claiming to protect. If we want fairer results for consumers, and we all want that, then consider this. Just 13% of class actions actually provided a benefit to consumers, and the average payout was roughly $32. Plaintiff lawyers, on the other hand, make about 31,000 times that amount, earning an average of $1 million per settled case. Consumers who obtain relief in arbitration recover on average $5,300. Again, contrast that to the $32 average class member recovery. That means folks using arbitration are about 166 times better off than folks who become party to a class action. This rule is typical of CFPB's Washington knows best mentality. Companies will abandon markets and products because of the lawsuit abuse that this rule invites. This will drive up costs and reduce choices for consumers, and doesn't that fly in the face of the CFPB's alleged purpose? I note that the Office of the Comptroller of the Currency has expressed legitimate concerns about this rule. The increased cost of litigation could harm the safety and soundness of the federal banking system. Community banks would have to hold greater reserves because of future expenses associated with litigation, which would reduce lending. Finally, this is precisely the type of abusive rule one might expect from an agency that the D.C. Circuit Court of Appeals described as having massive and unchecked power. Indeed, the D.C. Circuit said last year, other than the President, the Director of the CFPB is the single most powerful official in the entire United States government, at least when measured in terms of unilateral power. That is not an overstatement, the court said. Again, arbitration is up to 12 times faster than litigation, according to the Bureau's own study. Yet, despite its own findings in its own report, that arbitration produces better, faster results for consumers than class actions, the CFP plowed ahead with this rule, much to trial lawyers' satisfaction. That is why the people's representatives have introduced a resolution. I introduced H.J. Res. 111 this morning under the Congressional Review Act to stop this bureaucratic abuse.
We'll now hear from Blaine Lukemeyer from Missouri, Chairman of our Financial Institutions Subcommittee.
Thank you, Mr. Chairman, and thank all of you for being here this morning. I want to especially thank, Mr. Rothfuss here, as the Vice Chair of our Financial Institutions Committee, for his leadership on this issue, as well as Chairman Hensling's unwavering commitment to consumers and a more responsible regulatory regime. The Bureau's arbitration rule is proof of what we've said for years. The Consumer Financial Protection Bureau is not in the business of protecting consumers. Since creation of the Bureau, consumers' costs have gone up, and access to financial products have been severely restricted and, in some cases, evaporated altogether. And now the CFPB wants to further harm the very consumers they claim they are protecting, as my colleagues have so eloquently stated here, by their own data, which shows that it doesn't work. The simple truth of the matter is that arbitration helps consumers. Once again, this is just another example of Washington bureaucrats looking out for their friends at the expense of the American people. The promulgation of the arbitration rule is precisely why Congress has the oversight tools granted to it under the Congressional Review Act. It's time for Congress to intervene. To close, we believe this rule will have devastating consequences for American consumers, and we are anxious to begin the process. And I want to thank my colleagues for all their hard work on this, and we'll turn it back to the chairman.
Questions?
How many of your fellow Republicans have signed on to this, and how many Democrats?
I believe we have all of our Republicans on board. No Democrats. All the Republicans have signed on. All the Republicans on the committee have signed on. Next question.
The success rates on the class actions and the payouts, but I'm curious, what are the success rates on arbitration for consumers and the payouts? Do you have those statistics as well?
Well, we have a lot of statistics we can provide you with, but the CFPB rule has to be based upon their own study. And we know what their own study says, and those were the statistics that we were quoting, that shows, again, that the average recipient in a class action suit is getting $32 and the lawyers are getting $1 million. Well, in an arbitration, you actually get to settle on the merits. And we also know under CFPB's data, I think it's roughly 85, 87% of the class action suits lead to nothing for consumers as well. But I will share with you data that is independent of the CFP, because a lot of study has been done by the U.S. Chamber and by others. I don't quite have that statistic at my fingertip, but I'll get it for you.
Is there a legislative fix, Mr. Chairman, or a delay type of legislative fix that you could do? As you mentioned, the chairman is likely not going to be leader of the CFPB much longer.
Well, this is the bill filed by Mr. Rothfuss. This is the legislative fix. The Congressional Review Act will undo this rule. And so we are acting today. I believe on the other side of the Capitol, the Senate is acting today as well. And we expect to vote on Mr. Rothfuss's bill in fairly short order.
Just a quick follow-up with regards to any restructuring. There's a lot of conversations being had about tax reform. Are you hopeful, or is it possible that any type of Dodd-Frank type of ramifications could be juxtaposed with tax reform?
Well, as you know, the House has passed the Financial Choice Act, which functionally repeals and replaces Dodd-Frank, and there are major provisions of that legislation that can go through the reconciliation process, as can tax reform. I continue to look for multiple vehicles in which to carry that policy, including the appropriations process, and large portions of the Financial Choice Act are in the appropriations bill that is working its way through the system now. Next question.
Should we look at this CRA as an indication of things to come for potential future CFPB rulemakings? They just finalized this a week ago, and Congress is already stepping up and introducing resolutions to get rid of it. Is this an indication that if under Cordray the CFPB offers more rules, Congress is just going to try and repeal them again?
Well, if they offer rules that ultimately are going to hurt consumers, the answer is yes. Unequivocally, yes. We will act judiciously. We will act expeditiously to protect consumers from the Consumer Financial Protection Bureau. Next question. Yes, sir.
So does leadership support this? When can we expect the floor vote?
Yes, they do, and soon. But I would ask them on the precise timing.
Last question.
Okay. Thank you very much.